I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about the case Marathon Oil Company versus EPA. This is a 1977 decision from the Ninth Circuit, and it's in our casebook as a contrast to the Florida East Coast Railway case that's positioned right before it. And both are about when a hearing that the Administrative Procedure Act calls an on-the-record hearing is required. So it's similar legal issues, but the two opinions reached or cases reached different results. Now, Florida East Coast Railway is a U.S. Supreme Court decision and is more typical for the results in this area. But there are some distinguishable facts here that may help you understand the boundaries or parameters of the legal rules that the courts have laid down. So let's dive in. So, a lot of regulatory agencies will create a permitting regime where private parties in the regulated industry have to apply for permits. And sometimes these permits come with pretty strict rules or eligibility requirements or restrictions. And other times, maybe people are denied their application for a permit. And that's what this case it really started with. There were some oil companies, including Marathon, that were operating in a place called Cook Inlet, Alaska. And they sued the Environmental Protection Agency, or EPA, because of the EPA's permit and effluent limits under the Federal Water Pollution Control Act. So this is actually about water pollution, not air pollution. And the section is 40212. That doesn't really matter for purposes of our course, though. And the question is, what procedural protections are private parties entitled to in these issues with or these decisions about permits, either the rules about what you have to do to get a permit or someone who has been denied a permit application or had their permit revoked. Now, our relevant statute here, as I mentioned, is the Federal Water Pollution Control Act. And the section at issue required, and like the text says, that the agency has to offer an opportunity for public hearing regarding its permits. So the agency has statutory authority from Congress to create this permitting regime, but it says that they're supposed to provide an opportunity for public hearing. And the EPA did not interpret this as requiring a full formal hearing or adjudication under the Administrative Procedure Act, as in set forth in sections 554, 556, and 557 of that act. The oil companies here, led by Marathon, contended that the EPA actually was supposed to offer a formal adjudication, like with an administrative law judge and hearings where evidence would be taken and then a final decision that's written decision based on the record if the agency is going to deny their permits or set special conditions that are really strict and so forth. Now, under the Administrative Procedure Act, what we're really talking about here is that formal hearings or formal adjudication is necessary when adjudications are required by statute to be determined on the record after an opportunity for agency hearing. And so the specific phrasing on the record was actually absent from this statute. In some of my other videos, I talk about how that phrase actually really matters. It's a legal term of art, and on the record decision has tended to become equivalent under Supreme Court precedent with formal adjudication under the APA. But the court here says that that's not an absolute rule. So let's keep going. So let's talk about the holding in this case. The Ninth Circuit said that setting effluent limitations under the relevant statutory section here is clearly adjudicatory in nature. In other words, we're making decisions about what individual parties have to do or whether they're going to get permits. Now, we're not talking about lone individuals. We're talking about corporations like Marathon Oil Company here, but it's still adjudicative. We're not just setting a general policy or a universal rule. And so the Ninth Circuit here holds that the special protections of Section 554, 556, and 557 of the APA are required. And when it comes to the on the record language, the court held that the absence of that in the statute in this case is not in itself dispositive. In other words, it could be relevant, but they're saying that that doesn't make or break the decision on its own. The court takes a kind of pragmatic approach here, or focuses on how this actually works in practice. So they focus on the substance first and say that the applicability of the formal adjudication provisions of the APA really depend on the substantive character of the proceedings involved. And the proceedings involved in this case under the relevant enabling statute determine the specific rights of particular entities or corporations. And these often involve what the quote says, sharply disputed factual issues, right? So you have industry competitors that may have different interests, and also an industry player like Marathon Oil that's been doing this for a long time, and they may have a firsthand knowledge that they think that the EPA has misunderstood the situation. And then the court very pragmatically says that there are benefits in the formality of having a hearing. The adversarial hearings are helpful for reasoned decision making and for having meaningful judicial review after the fact in these types of cases. In other words, if we hold a hearing, we're more likely to get all the facts out so we know we're not making a mistake or reaching an erroneous conclusion. And also later, if this then ends up in court where the parties are still litigating about it, the courts will have a better record of what happened and a clearer factual picture to work with if there was a hearing with evidence submitted and a written decision on the record describing the evidence and how it was weighed and so forth after the fact. Keep in mind that licensing, or permitting, is explicitly included in the APA's definition of adjudication. And the on the record language in APA Section 554, according to the court here, was intended by Congress just to exclude governmental functions that were traditionally not seen as adjudicative, rather than serving as a specific trigger phrase for future statutes. Now, the Administrative Procedure Act requires agencies to confine themselves to the record when they're making adjudicatory determinations. But here, the court felt that the EPA administrator didn't really do that. He had apparently considered some evidence from outside the record, maybe some new information that was submitted at the last minute, something else called the Lieberson Memorandum, and so forth. You don't have to worry about what that is. Just understand that in formal adjudication, there's a fixed record of exhibits or what evidence has been submitted. And if we're doing formal adjudication, the agency isn't supposed to be relying on anything except what's in the record. And it looked like they had done that here, so the court remanded it to the agency for some new hearings. So what was the outcome? The court issued a remand, but limited it to require new hearings and challenge the extra record material, but it did reject a constitutional challenge that the parties had brought. The purposes of the remand, according to the court, was for the EPA to provide an exposition, it calls it, of the extra record data and the memorandum, and to conduct some new hearings so that petitioners could comment upon or challenge this new evidence. In other words, the fundamental unfairness here is maybe we have hearings or an opportunity for parties to submit evidence and comment or try to rebut the evidence against them that the agency's using. And then later on, it turns out when they get the decision that the agency considered some further evidence that they didn't know was at issue. And so a remand and new hearings will give Marathon Oil and the other oil companies the opportunity to say that this evidence is not reliable or it doesn't really apply in the way you're saying it does, or something like that. So, when we're talking about agency hearings and the rights of parties, there's always this question of what about third party rights, like parties that are going to be affected by what the agency decides, but they're not parties in the litigation in this case. So maybe there's a nearby property owner who's going to be affected by an oil company getting a permit to pollute the local water supply. So they definitely have a legal interest in the outcome, but they are not really involved in these proceedings. The general rule is that third parties have no right to demand hearings for others' rights, but there are exceptions. And there's a public interest exception where maybe an advocacy group that's representing the public interest could have a right in some circumstances to demand that the agency provide a hearing. Or there are some situations where there's mutually exclusive applications for a permit or a license. So it's really going to be comparative hearing that's needed when granting one application means that you've precluded another. The textbook example of this would be broadcast licenses. You can't have two broadcasters on the same bandwidth or frequency. So the Federal Communications Commission or whoever's issuing these is going to issue them only to one, which means somebody else who really wanted to broadcast at that frequency is going to lose out. And in those cases, the parties that are going to lose if one wins, if it's a zero sum game, may have hearing rights. So let's wrap this up. That concludes our lecture about Marathon Oil Company versus EPA.